In week 11 of CLAW2214, we talk about the company's organs. So we talk about the board of directors and shareholders. There's quite a lot to talk about here. So the company's organs, so constituents of a company. Last week we talked about the formation of a company, the sort of status of a company, but a company consists of persons in the following capacities. So we have directors, officers, and members. Directors usually, but not always, are often also members. They are collectively the board of directors, and officers are the includes directors, but these are, for example, people like CEOs, CFOs, and members. These are the shareholders, or the companies are limited by shares. The board exercises management power. Businesses of a company is managed by by or order the direction of the directors, i.e., the board, exercise all the powers of a company as contained in S124, responsible for strategy, accountability, supervision, and policy. Quorum at board meetings is 2 directors per replaceable row. Can be amended by the Constitution, and passing of a resolution, a simple majority vote. So the definition of director, a board of directors, as directors are companies to include properly appointed directors, properly appointed alternative directors, de facto directors, and shadow directors. Directors, managing directors, or CEO, a director who is appointed under Section 102J to exercise the Section 198A powers of the board of directors as conferred by the board. So powers generally such as de facto MD, who is not validly appointed as MD, but nonetheless acts as the position of MD. Chair of the board of directors has responsibilities for leading the board, facilitating effective contributions of all directors, setting the board's business agenda, ensuring the provisions of information to the board, and casting votes to avoid deadlocks. Directors, executive directors, for example, MD, CEO, CFOs. These are directors who is full-time employees of the company and can be hired or fired. Non-executive directors are part-time directors. These are not an employee of a company, having responsibilities to attend board meetings and sit on board committees as required. It has an important function regarding the monitoring and accountability of the management team. So directors, non-executive directors have 2 types. There's affiliated non-executive directors. So a non-executive director who has a present or past connection with the company. Or independent non-executive directors are non-executive directors who do not nor have been connected with the company in a way that could materially interfere with the exercise of independent judgment in managing the company. Directors a number of companies, so proprietary companies are proprietary companies, so these are PTY Ltds. There is a requirement for 1 director who must ordinarily reside in Australia. For public companies or limited companies or Ltd companies, there's a requirement of at least 3 directors. 2 of least must ordinarily reside in Australia, who can be directors of PTY Ltd companies, so you have to be at least 18, and a natural person. Directors' appointments. So directors can be appointed either on incorporation or after incorporation. If it is on incorporation, that has to be named in Form 201. If it is after incorporation, then it is appointed by resolution in a general meeting. If vacancy, then board can appoint directors for proprietary companies, shareholders confirmation within 2 months, or public company shareholder confirmation at next annual general meeting. Director removal and disqualification. So removal of a director. Directors can be removed from office by a shareholder resolution, but cannot be removed by the board. So disqualification, automatic disqualification, disqualification by ASIC, or disqualification by the court. For example, you could no longer be a director of a company. If a court says that, then you would be removed and disqualified. Automatic disqualification. So if a person is convicted of offense concerning company management, Corporations Act, offense having longer than 12 months of jail, offense of dishonesty having at least 3 months of jail, offense of laws of foreign country having more than 12 months of jail, disqualified for the period that the person is an undischarged bankrupt, or bond by personal insolvency agreement not yet complied with disqualification from managing company by foreign court. Disqualification by ASIC, so disqualified person for managing companies for at least 5 years if in the last 7 years the person is an officer of two or more companies that have been wound up and unsecured creditors have received $1 or less. Directors, so this is just a thing to ensure that unsecured creditors have received something. Director's disqualification by courts. So on ASIC's application, a court can disqualify a person if breach relevant civil penalty provisions. Disqualification for a period court considers appropriate. In the last 7 years, officers of two or more failed companies and management partly responsible for failure, or disqualification for up to 20 years. So officers, so there is a broad definition of what officers of a company can include. It could include directors, a company secretary, person who makes or participate in making decisions affecting the whole or substantial part of a company's business, such as senior managers or consultants, a person who has capacity to significantly affect the company's financial standing, such as senior managers, shadow officers, and insolvency controllers. Officer defective appointments and acts. An act done by a person acting as an officer is effective even if their appointment or the continuance of the appointment is invalid because the company or person did not comply with the company constitution, if any, for any provisions of the Corporations Act. For example, a person's act calling a meeting of a company's members or signing a document to be lodged to ASIC or minutes of the minutes is effective despite the effective appointment of to the person's office. To be effective, the act must be done by a person who appears to be an officer or who appears to be recognized as such by the company's officers, associates, or associates. So it doesn't have to effective even if they are invalid. So just appearance, a reasonable person appearance. Qualification that are mandatory, such as 18 years old, is mandatory. A qualification in accounting, finance, or law is optional. For the company secretary, proprietary companies are required to have company secretary if having one or more secretaries, that at least one must ordinarily reside in Australia, must have at least one company secretary, at least one of whom must ordinarily reside in Australia. The company secretary is responsible for administrative matters, including companies having a registered office of a public company open to the public, responding to extract of particulars from ASIC, responding to a return of particulars from ASIC, lodging of various notices with ASIC, lodging the financial reports, and general laws and responsibilities from the company secretary. Members and shareholders, the main functions or the organs of the company. The members in general meetings constitutes an organ of the company and as such are entitled to vote on certain resolutions of the company. Fundraising, the members purchase shares and options in the company, thereby providing equity finance for its deployment. Accountability of the management. A member can hold the management accountable for the performance of the company and can apply to seek for remedies on behalf and can appoint or remove directors. A member of companies. All companies must have at least one member, which is a shareholder. Proprietary companies up to 50 members that are non-employees, and public companies have no maximum shareholder numbers. Becoming a member, you could become a member on incorporation via Form 201. After incorporation, through the issuance of share by company or transfer of share by members. Transmission of shares, for example, through bankruptcy or death of a member. Register of member on these forms must be established and maintained. Strict liability offense, 10 years penalty units, and 3 months jail, for example. Issue of shares, so directors may exercise the company's power to issue shares. Company members in general meetings can determine term of issue, rights and restrictions, preemptive rights for existing shareholders, and applies to proprietary companies only. Before issuing shares of a particular class, the director of a proprietary company must offer them to the existing shareholders of that class. These are preemptive rights of existing shareholders that could be written into the Constitution. Transfer of shares. So shares are personal property of members and are transferable, subject to Constitution or applicable. Listed companies cannot have transfer restrictions. So electronic transfer, for example, to CHESS, the Clearinghouse Electronic Sub-Register System. For non-listed companies, any transfer restriction must be clear and unambiguous in the Constitution or the shareholders' agreement. Preemptive rights to existing shareholders on transfer, for example. Members versus directors. So members are shareholders versus directors. Powers reserved for exercise only by members, so cannot be exercised by the board, include appointing directors, removing directors, amending constitutions, changing company type, changing company name, voluntary winding up, issuing preferred shares, terms of issues, for example. Members cannot override decisions made by the board of directors when the board has full management powers. Members cannot seek to involve themselves in or interfere with the board's management of the company. But once again, the boards derive their power from the members. Members cannot propose non-binding advisory resolutions that purport to express an opinion as how the directors should exercise their management powers. So these are certain case law that expands on situations in accordance with the provisions of the Corporation Act of 2001 and the company constitution. Members in general meetings can question board and have their ability to decide certain company resolution, propose resolution to effect the removal of directors. Okay, so members can remove directors, but members cannot propose non-binding advisory resolutions. Nor can members override decisions made by the board of directors when the board is full of management powers. Members meeting and shareholders meeting. So members meeting, or aka shareholders meeting for company of limited by shares, are required to exercise any power of the Corporations Act or the company's constitution requires the company to exercise in a general meeting, including such as the following. Also exercise any powers of the Corporations Act or company's constitution, if any, requires the company to exercise in general meetings, including business of AGM, such as consideration of annual reports, adaptation of remuneration reports, election of directors, voting on resolution, removal of directors, for example. Members' meetings aka shareholders' meetings are similar to directors' meetings in that they constitute an organ of the company. They involve the democratic processes of organization. Resolutions are decisions made by the company, different to directors' meetings in that they are meetings of members who can include directors but voting in their capacity as members. Special resolutions can be proposed and decided on issues that are reserved for the votes of the member, such as constitutional amendments, changed in company type, for example. Members' meetings and shareholders' meetings, types of meetings, AGM, EGM, and class meetings. So AGMs for annual general meeting is required under the Corporations Act. Extraordinary general meeting, these are members meeting under the AGM held as required. And class meeting, meetings of a member of a specific share class. Member meeting power to call meeting. Member meeting can be called by directors. Directors as requested by members if you have more than 5% of voting rights. Members where directors fail to call meetings are at request of a member. So if the board did not call a meeting within 21 days after a member had requested a meeting, members with more than 50% of the vote may call to hold a general meeting. Okay. Members meeting power to call meeting. So members meeting can be called by members. Has 5% vote can be cast in general meeting called for and arranged to hold a general meeting. The member calling the meeting must pay the expenses of calling and holding the meeting. Courts, so on application of any director or any member entitled to vote, if impractical to call the meeting in any other way. For example, quorum is not met. Members meeting notice. So companies' written notice must be given individually to members entitled to vote and to directors by post, faxed, email, for example. By post, given 3 days after posting. Fax, email, giving a notice giving next business day, for example. Non-listed companies, 21-day notice is required. Members meeting notice, if a public company removing directors, then an additional is giving at least 21 days notice at the meeting, and 2 months notice of the intention to move the resolution to remove directors must be given to the company. If a company is removing auditors, then in addition to giving at least 21 days notice of the meeting, at least 2 months notice of the intention to move the resolution to remove auditors must be given to the company. Listed companies, more than 28 days, no exceptions for removing directors and auditors. Members meeting, quorum, and location. So members must be held at a reasonable time and place. Have a quorum of 2 members present at all times during the meeting. Have quorum present within 30 minutes of commencement. Time set out to the notice, or if not, the meeting must be adjourned to the date, time, and place specified by the directors. Members meeting, resolution, and voting. Ordinary resolution or a resolution that has been passed by a simple majority. That's pretty straightforward. Members meeting, resolution, and voting. So special resolution, a resolution that has been passed by a super majority, that's at least by 75% of the votes, cast by a member entitled to vote to a resolution, whether the voting is by person or by proxy. Yes votes are counted in favor to resolution. No votes are against. It's pretty straightforward, actually. Absence without are abstentions, irrelevance, and disregarded. Members meeting, resolution, and voting. Voting on resolutions. Voting on resolutions. Shares, company limited by shares. So ownership of shares by members, shareholders involves acquisition of shares, and entitles the owner to be registered as a member of a company. Payments of the price of the share provides equity finance to a company. Nature of shares. So shares are personal property and could be transferable. We talked about that. A share confers upon the holder no legal or equitable interest in the asset of the company. If it is a separate piece of property, as distinct from the unit of a trust that's subject to the deed. Company limited by shares, so interest in shares can be either legal or equitable for members for beneficially held shares, where shares directly benefit the person who holds them, or legal for trustee and equitable for beneficiary. For example, non-beneficially held shares, where shares are held in trusts or by a trustee for a beneficiary. Company limited by shares, directors usually have an exclusive power to manage to issue shares. So ordinary shares, partly paid shares, and preferred shares. Classes of shares could be different classes with different voting rights and obligations. For ordinary shares, they have the following general characteristics. They're fully paid for. Share types must mostly traded on the ASX. Right to vote, right to participate in dividends as declared, right to participate in any distribution of surplus assets when winding up. Partly paid shares, also known as contributing shares, are issued without the company requiring payment of the full issuing price of the time of issue. At specified future dates, the company is entitled to call all or parts of the outstanding issue price, and the shareholder at the time to call is due to legally obliged to pay to call. No liability mining companies are not required to specify the date. For example, generally a holder of partly paid shares had the same rights as ordinary shareholders to vote and to dividends and to winding up, as accompanied by these rights will be proportioned to the amount of paid on the shares. Full rights are not bestowed until the shares become ordinary shares or are paid up. Preferred shares. The preferred shares usually give the holders priority or preference when it comes to dividends, so repayment of capital. You guys are accounting students. You should know what these are. Preferred shares, dividends. Fundraising disclosure requirements. So we got prepared companies can engage in fundraising activities required under disclosure and whatnot. Fundraising exceptions. Fundraising disclosure documents, equity crowdsource fundraising. And yeah, so this is week 11's content. Hope you took something away from it. Without further ado, take care and goodbye.